I'm Pete Dolack. I also work with Trade Justice New York Metro. I also write the Systemic Disorder blog, which is about the economic crisis and the political issues surrounding it. And I also write on the Systemic Disorder blog ideas for how to do things a little bit better. Certainly banking is one of the issues that I like to cover on that. It's a critical issue. So we're here to talk about the Trans-Pacific Partnership, something that many people surprisingly still don't know about. But on the other hand, it really isn't surprising that many people don't know about it because it's being negotiated in secret. It's a top secret thing. They don't want anyone to know about it. And there's a good reason for that, because if people know about it, as in fact the former United States Trade Representative said in an open movement, if people knew what was in this, they'd be up in arms against it. And that's the one time we were in agreement with the United States Trade Representative. That was Ron Kirk, who used to hold that position, or somebody new who just came in, who a longtime Citibank executive, and somebody used to be the chief of staff for Robert Rubin, who oversaw Clinton's dismantling of financial regulations when he was president. What is it about the Trans-Pacific Partnership? And sometimes people who know about it will often use the phrase, it's NAFTA on steroids. And if you remember nothing else, remember those three words, NAFTA on steroids. Now, most people are familiar with the North American Free Trade Agreement, where they have all sorts of laws in effect, and corporations can sue anytime the Canadian, the US, or the Mexican government say, well, you actually have to not dump your dangerous chemicals into the water supply. And they consider this an affront. Why, this will hurt profits. And they can sue, and usually they win. Well, they're going to take this model and they're going to expand it and make the conditions under which a corporation can sue even greater. They've got this concept called investor rights. Now, I've looked through the US Constitution, and I've never ever heard, there's no mention of investor rights. There's no mention of investors at all in there. And as far as I know, no other country has a constitution that talks about investor rights. Now, they may talk about free speech rights or inalienable rights or rights of those sorts, the rights to vote, etc. Other countries that are more advanced than the US might even talk about rights to education and health care. Of course, in the US, we don't have things like that. We should, but this is not an advanced country, unfortunately. But somehow in these multinational trade organizations, we have something called investor rights. And what's really interesting about this is that investor rights supersede any other kind of rights. Basically, what they said is the corporation, or in the parlance of these agreements, the investor, has the right to a guaranteed profit. And any rule, any regulation, any effort to hem in their activities, it's an illegal taking of their right to a profit. I don't explicitly use that language, but that's what it's about. Again, it all comes down to investor rights. And the problem with this, among others, is that there's no limit on who an investor is. An investor basically is any entity, any person, anybody who invests or announces an intention that they might invest. It's that tenuous that they intend to make some kind of investment. Either they're going to buy something, or they're going to buy a forest because they want to chop it down for a paper mill, or to gain access to a natural resource. Whatever it is, they don't even actually have to make the investment. They just have to intend to do it. And at that point, the investor rights would kick in. And at that point, so any regulation or rule that says, well, no, wait a minute, you can't take your raw chemical and dump it into the aquifer. You can't do that. And the corporation will be able to say, well, my investor rights are being violated here. And so they go to an arbitration board. And I have to look up the name because I can never quite remember the name of it. There's about 3 of these, one of which is the London Board of International Arbitration. But the key one here, I think, will be what's called the ICSID. And if you excuse me for a moment, I can never quite remember the name of it. It's a bit of a mouthful. I do have it here. It's the International Center for Settlement of Investor Disputes, ICSID, or ICSID for short. And what's interesting about that is that's the arbitration board that is used when there's a dispute in NAFTA. So, for instance, there was a case where there was a U.S.-based chemical corporation called the Ethel Corporation, and they were one of the prime makers of MTBE, which they were using as a gasoline additive at one point, of highly toxic stuff. If it gets loose, it goes straight into the groundwater, and whatever groundwater is in the vicinity gets very quickly contaminated with it. It's very difficult to control. So the U.S. finally, at some point, put some restrictions on it. They didn't completely ban it, but they put some restrictions on it. Now, Ethel went into Canada. Canada at this time was not using MTBE in it as a gasoline additive, but Ethel thought, it'd be a really nice idea if Canada would do it. We think we can make some profits here. So they went into Canada, and there was enough organization in Canada that they wound up getting the Canadian government banned the use of this. Ethel Corporation, under the provisions of NAFTA, said, hey, you're violating my investor rights. You're taking away you're confiscating my profit. And so it went to the ICSID, and sure enough, the ICSID said, bad Canada, bad, bad, bad. You're taking away that poor innocent corporation's right to a profit. So Canada had to rescind its ban on the polluting chemical. They had to pay them a settlement of several tens of millions of dollars to compensate them for their lost profits and issue them an apology. This is what happens under it. And who is on the ICSID? People don't realize, because these things, they're very shadowy and they're off in the distance there. And the ICSID is actually an arm of the World Bank. So think about this. The World Bank says to countries all over the world, oh, you need a loan, fine, we'll give you a loan, but you have to implement all this austerity if you're going to get this loan. And if you don't do everything that the World Bank tells you to do, which of course is at the behest of the corporations, because the World Bank and the International Monetary Fund, these are not somehow floating in the clouds in the ether above everything. These are controlled by the most powerful capitalist countries, the US in first place, but certainly the European Union and countries like Japan and South Korea, all the advanced capitalist countries, and they in turn are advancing the interests of their largest corporations. So the World Bank imposes all this austerity on you. You don't do every letter that they impose. The corporation then sues, and what do? They sue in the ICSID, in the arm of the World Bank, which is controlled by the World Bank. And then the World Bank decides on this. And who are the judges on it? Ultimately, it's an arbitration tribunal, and there's 3 judges who sit on these things. There's a whole big panel. Every country that's a signatory to these arbitration agreements put somebody in there, and then from this pool of judges they pick 3 on it. So it sounds like, oh, judges, it's neutral, where they pick somebody who sits on the federal court or the equivalent in another country. But it isn't that way at all. The judges, believe it or not, are actually corporate lawyers who represent the corporations who are suing the government. This sounds really incredible, but it is. So there's in fact eight. I won't go through all the names. I have this up in the front. It's got more of these details if you're interested. But there's 8 judges who are among the panels, and they're all actually appointed by the Bush II Cheney administration. Apparently they have such long terms. Obama hasn't had a chance to appoint anybody, though I'm sure he would appoint the same kind of people. It's just the ones that donate to Democrats instead of the ones that donate to Republicans. But every one of these 8 judges works. 6 of them work for a major corporate a law firm that specializes and is actually specialized in representing the corporations in front of these kinds of boards when they're in disputes with governments, and a couple others are actually corporate lobbyists. And this is supposedly the independent people who judge in this. So needless to say, it's not a real big surprise when you find out who the judges are that almost every time, unless it's an incredibly egregious one, about one of the very few that the country actually won is somebody, UPS actually sued Canada to say that the Canadian Postal Service was an unfair advantage, and actually sued for Canada to dismantle their postal service. And that was too much for even these. But given that the TPP, the Trans-Pacific Partnership, is going even further, that may not be the case in the future. You may be able to sue and get maybe even the U.S. Postal Service dismantled, because that's one of the things they're trying to do now is to get that's why they're trying to kill off the Postal Service, because it'll make a killing for UPS and these other private postal services. So the whole thing, and the interesting thing is these tribunals, stacked as they are, to really ensure that they're one-sided, they're held in secret. And most of the time, there's no public calendar, so nobody even knows when they're even going to take place. And even if you knew, they're closed to the public, so nobody can even be in there. So it's a completely private, corporatized system of justice, very much in quote marks. And that's already what we have on NAFTA. And under the Trans-Pacific Partnership, they're going to use NAFTA as the base. And say, okay, we got all this in NAFTA, and how we can go further from that. So one of the ways that they're going to do it is they're going to expand the definition of an investor. Sorry here, just go, right. So they're going to expand what constitutes an investor. So it's anyone is eligible to file a claim under these kinds of trade agreements. Anyone who applies for a permit or a license or, in quotes, channels resources or capital to set up a business and without placing any limits on what constitutes channeling resources or capital or applying for any kind of permit or license. There's no language to block frivolous claims. So any corporation can make a claim no matter how absurd it is. And even in the rare cases when a government wins these cases, the government is on the hook to pay for the lawyer costs. So they don't even do it. At least if they had a provision to say, well, if you bring a case and it's frivolous and you lose, you've got to pay for the whole thing. They have nothing to lose because the government picks up the lawyer costs. So they have absolutely nothing to lose on this. They're going to require new intellectual property laws. Basically, different countries have different regimes when it comes to intellectual property. And what they're going to do is basically usually the U.S. has the most draconian laws in this kind of field, and are going to basically adopt the U.S. laws in this. One of the things they're going to do is basically significantly tighten up the control of the internet. So basically, any government that goes or any corporation that wants private data handed over to them, they'll be able, under the provisions of what they're negotiating in Trans-Pacific Partnership, every ISP or internet service provider will be required to hand over anybody's personal data, and there will actually be restrictions in there. It's quite conceivable that there'll start to be corporate censorship over the internet, because they'll deploy intellectual property laws in these kinds of manners. Now, this is actually being negotiated. This has been in secret negotiations for about 3 years now. And they have a round. In fact, I believe the Malaysia round is coming up in later this month, and I think in about a week. About every 3 months, they have a round of negotiations, and then they rotate it around the various countries. Originally, there were 9 countries that were signatories to these negotiations. Since then, Canada and Mexico have signed on, and with this round in Malaysia, Japan will now sign on. So there's now 12 countries, very widely dispersed. You have really leading advanced capitalist countries like the US, Canada, and Japan in this, asserting their interests, being at the top of the capitalist world food chain. But then you also have developing countries like Vietnam, Malaysia are involved in this, and then you have kind of, let's say, middle-ranking countries like Chile and Peru are also involved in this. So we will run the whole gamut of this. So basically what's happening is the most powerful countries are going to impose their rules on the developing countries that aren't as strong, and basically just crack them open like they're a nut, like they're a shell. That's really what's good. This is all about. It's about resource extraction. It's about financialization, because one of the aspects of this is that rules, capital controls, for instance, would be explicitly illegal under the Trans-Pacific Partnership. Any kind of regulations to control the financial industry, that would also be illegal, because it would be considered a constraint on free trade. Free trade simply would mean anything any corporation wants to do that it believes it can make a profit, it will be allowed to do, full stop. And so any kind of financial regulation, any kind of local buying regulations like Buy American or Buy Local or any such equivalents in other countries, these would be all illegal. Countries like Australia and New Zealand, they're also signatories to these negotiations. They have much better regimes when it comes to medicines and pharmaceuticals. They make it much easier. They force lower prices on the pharmaceutical companies, and they make it much easier for generics to get to market. Under the Trans-Pacific Partnership, all that would be illegal. The U.S. regime, which is the most strict in terms of guaranteeing the highest possible prices for pharmaceuticals and the longest delay in time until a generic can come onto the market, that would be the regime that would be imposed on all other countries. So countries, not only in other countries like Australia and New Zealand, but developing countries like Malaysia, Vietnam, and countries in Latin America, for instance, who want, they will be greatly restricted in their ability to allow affordable medicines to be made available to their populations. This is a real nightmare. So whatever your interest is, Trans-Pacific Partnership impacts on it, because it comes into every industry and impacts every aspect. Basically what this means is that a multinational corporation's rights to profits will become a superseding right above everything. So literally the highest task of national governments will be to maximize corporate profits. Maximizing corporate profits will be codified in law, because this will now supersede all national laws. So for people who are worried about issues of sovereignty, for instance, that's out the window. Okay? What's interesting about this is that it actually gives corporations from outside a country more rights than it does to a corporation suing within its own country, because these trade agreements and the decisions that get handed down in these secret arbitration tribunals, and by the way, they have a force of law in the same sense that they become a binding precedent. So if a precedent gets even more severe, that now becomes a new floor. So now, so that's a starting point for the next one. And so in stages, they just, make it more and more draconian. So even beyond whatever the intentions may be or what these corporations believe they might be able to get within these agreements, they'll gradually get more. For instance, there's also various bilateral agreements, because the GATT negotiations have been bogged down for over a decade now. So for instance, one of the strategies of the U.S. is they have these bilateral agreements. There's a U.S.-Colombia agreement, there's a U.S.-Ecuador agreement, there's a U.S.-South Korea agreement, for instance. And under the, and of course the agreement with Ecuador was signed before Rafael Correa was in office. They had a neoliberal government in Ecuador at the time. And there was a ruling in July 2005. Occidental Petroleum Company, which I believe is based in California, but in any event, it's a big chemical and oil and gas company that's based in the U.S. They actually sued under the U.S.-Ecuador bilateral investment treaty, and this is, very similar to NAFTA. It just applies to two countries instead of a larger grouping. And basically, the Ecuadorian government had made a change in the regulations that affected Occidental Petroleum and the resource extraction there. So they sued under this, and this actually went to the London Board of International Arbitration. It's very similar. It operates the same way as ICSID does. It's just a separate one. And they actually ruled for Occidental Petroleum and said, oh no, you can't put in a new regulation that affects the complaining corporation's business, and that's illegal under the treaty. So if that ruling gets accepted by ICSID or any other of these arbitration boards, that essentially that means potentially that any new regulation, any new tax, any new law that would affect a corporation, and i.e. therefore would cost them $1 in profits, under this precedent, that would be illegal. And this is the kind of thing that they're trying to put into the Trans-Pacific Partnership. And I know we're here to speak more at length in banking and finance, and Adam Weissman, I will momentarily turn it over to him, and he'll be talking in more detail about those things. And that's one of the things that's key to remember about this, because of course the financial industry really has a stranglehold over everything. And I won't go, and that's a long structural explanation. I can talk about that another day if people want. But remember, what the excuse for this is that this is market forces. This is what we always hear. They always tell, oh, it's not in our control. It's market forces. The market is dictating this. Like the market is some amorphous thing up in the ether, suspended above everybody, and just acts all on its own, and no one has any control over this. But that's not what a market is. What is a market? What is a market? at least in capitalist economics. A market is simply the aggregate interests of the most powerful industrialists and financiers. And they have the power to impose their interests because they have decisive influence over governments, and their power in the market by virtue of having control of most every industry. And as they get bigger and bigger, they get more and more powerful, and they acquire more capital, and that's why it's capitalism, because it's the power of capitalism. Capitalism dictates power, and by doing this, they get decisive influence. So, you know, they have competitive issues between them, and there's always pushing and pulling, industrialists on one side, financiers on the other side, but they all have a common interest in keeping the system going because everything they do operates within this system. And that's what markets are. That's all markets are. It's the aggregate interests of the most powerful industrialists and financiers. And when you hear the markets dictate that, well, yeah, that is what Citibank wants, or that is what Monsanto wants. That's true, but that's all the market is. It's nothing amorphous, and that's one of the most, and that's one of the reasons why financialization has taken such hold on this, and that's one of the things that we'll be unable to control. You know, people's banking is what we need, bringing the financial industry under control and making, you know, I would personally advocate, you know, that banking should be a public utility. You know, it should be under public control, democratically controlled. You take in savings, you loan it out you know, for projects that are economically and socially useful. There should be no speculation of any kind. You can forget about doing anything like that if Trans-Pacific Partnership, but whatever your interest, whatever your particular interest is, whether it's banking and finance, whether it's safe and clean water, whether it's fracking, whatever other issue you might on, the Trans-Pacific Partnership impacts you. So everybody needs to know about this. That's why they're negotiating in secret, because they don't want everybody to know about it. If the Trans-Pacific Partnership goes through, it's game over. We'll have no control. We'll have no control over everything. This agreement will be completely in corporate hands. It will be a de facto. We always like to throw around the idea of corporate dictatorship. This will be a de facto corporate dictatorship. You know, we'll get to vote on which Republican or Democrat gets best to implement a corporate agenda, and that's about all that democracy will mean. That's about all it means now, but it will be even worse. This will be even worse. This is one of the most dangerous things that ever come down the pike. This is one of the most anti-democratic things coming down.